Welcome back to What I Missed TV. Today we are going to be talking about Fulton County prosecuting attorney Lying Love. She is currently prosecuting the YSL RICO trial and is doing a horrible job at it. She's wasting time and taxpayers' money. This video will show you how unprepared she is, Brady violations, and more. I want you to pay close attention to her body language and pay attention to how she's wording certain situations. Now let's take a look.
Said that everything you told the police, you made it all up. When did you make it all up?
You keep saying everything. I keep telling you, like, I know how to piece stuff together real good.
The stuff you made up, whatever parts you said you made up, when did you make it all up?
As I go.
Did you make it up with anyone else?
I don't recall. They looking at me like that.
Okay. Mr. Copeland, isn't it true that you're supposed to be testifying under an immunity agreement?
To be honest with you, I don't know. I don't have a clue.
Okay. Is your intent to show that entire thing with the whatever that heading is?
I was going to, Your Honor, if Mr. Copeland can recognize it, I was going to admit it into evidence, and it is from, we received in discovery from the state, and it's Operation Phoenix, and it's the authorities announced on October 29th, 2020, charges for the 12 most violent offenders in Operation Phoenix, and I was going to show that to him.
All right, and
then he has that on his Instagram, or I shouldn't say Instagram. It's a social media account. I think
and when's that social media post from?
That is, it's in his, oh, I'm being told the answer. It's in his biography or bio.
I can't hear what he's saying, but
He's saying it's in the social media biography of Mr. or bio of Mr. Copeland. I don't know the date personally, Your Honor.
okay. And how is any of whomever authority this was might have thought in October of 2020 relevant to the issues that we're talking about right now with Mr. Copeland?
I believe it's relevant because the state is saying that Jeffrey Williams governs this person. That's their whole theory. Tells them to go out. They're using one lyric from one song. Jeffrey Williams, as the court may not know, has thousands of songs that Woody's going to pop you in the noggin. That is the quote. And I want to show that they hardly knew each other. They knew each other for a short period of time. Mr. Copeland did not commit crimes for Jeffrey Williams. Jeffrey Williams encouraged Mr. Copeland to conduct himself lawfully. That was on a jail call that we heard yesterday. In fact, included on that, Jeffrey Williams, through his sisters, saying, get out of the streets, you have a child, you don't have to live that life. And I want to show that Mr. Copeland ignored all of that. And after he has no contact, he has zero contact with Jeffrey Williams, he is still putting on his social media that he is a gangster, or one of Georgia's most wanted. He is by the prosecution. These are federal authorities, by the way. So when I say prosecution, I'm talking about the federal authorities. Deemed him one of the 12 most violent offenders in Georgia in 2020, and he has done a interview with Off the Porch in April 2020, where he's stating that he's a real gangster, the other people are not. And that if you disagree with that, he's going to, straighten you out, basically. So I think that's all important to the jurors because it will hopefully undress this wrong impression, in my opinion, strongly wrong impression that the state is putting up that somehow this man is all around Jeffrey Williams, knows what he says, knows what he's thinking, he overhears him on conversations, and Jeffrey Williams is there when the police keep calling Kenneth Copeland. It just, in my opinion, and hopefully the cross-examination, that just wasn't their relationship. So.
Okay, well, most of what you mentioned already has already been put before the jury, and this particular exhibit does not in any way shed any light on whether Mr. Copeland is or is not close with Mr. Williams. And I just do not see the relevance of it, particularly given that he said he didn't know that that's what law enforcement thought of him.
Okay.
So I'm going to sustain that objection.
I understand. Okay. We will
All right.
move on.
Okay, so let's all break for lunch.
Can I just give this then to, it's on the thumb drive, of course, but can I just give this to the court reporter? It's the print, unless you don't want it.
No, yeah, that's fine.
But I understand it's not in evidence.
Correct.
In fact, you might not, because it's going to be a lot of, has Wright not admitted into evidence on it? Or?
That's fine. Okay. Excluded.
And you're on the old written, and step up for the next prosecution, that's what.
Yes.
No, Your Honor, but
Go ahead. Is there an objection, Mr. Sharp?
I'm assuming.
Speak into your mic so everybody can hear you. I'll do the same.
Yes, Your Honor. I'm assuming the state is saying that they're going to fast forward to the next time Mr. Copeland speaks. Is that correct?
he also speaks within this 45 minutes, but it's sporadic. And so we're going.
Well, I think the jury needs to hear what he says.
Oh, okay, well, we can send.
Well, I'm not trying to make, this is the state's evidence, and I'm not trying to make anyone sit for 45 minutes, but I want the jury to hear everything that Mr. Copeland says while he's alone.
Okay. Are you planning to play it at some point?
Your Honor.
You're going to go back to all his little, everything he says in that 45 minutes. We just, yeah, as long as they're going to play it. I don't know why they want to play it out of order, but whatever. That's fine.
Thank you, Your Honor.
His mother got shot while she was asleep in bed and all of those things, and I don't think that's appropriate either.
So Judge, based on the court's ruling regarding 1 through 4 up through 11 would be.
Yeah, all right. Well, you agreed with it. All right. So all the way through 101, line 11. Thank you.
I mean, it continues beyond 11.
Okay.
On January 10th, what's the relevance?
We agree, and that's something that if we decided to enter, we would have determined that. I don't know if this is the picture that we were going to enter, so it's the voluminous amount of information. I don't know if this is a picture.
Right, because y'all haven't exactly organized your case yet. All right, Mr. Sharp, they don't know whether they're going to use it or not. And they don't seem to, it would not at this point be admissible, but I can't tell you if it might be admissible at some other point when they get their case organized.
And you're right, it's not about the case not being organized, it's about whether or not we were using this particular piece of evidence. Like there we have a multiple of social media.
Right. Well, you don't know whether you're using it, and you don't know whether it is relevant. So, because you don't know when it was posted or why you think January 10th is on there. So we just don't know. So,
Your Honor, in the previous motion, the state asserted.
Ms. Love, I asked for my stapler back, Mr. Atkins, and it is not back yet. So I may not lend it to y'all again.
Yes, Your Honor. Thank you for letting me borrow it, Your Honor.
Okay. All right.
already has been examined and cross-examined?
Yes,
Okay, and no such recording was used?
right, they didn't.
Okay, then why would y'all be entitled to it?
It's just an example of something that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's
I don't
case.
disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not,
The court is
right?
correct.
Okay, so that one doesn't
scratch
matter.
it off.
Okay. So the Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody. I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail. They
Okay.
were from a different, but we've been provided, according to Defendant Williams, counsel for Defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there is no further issue.
Okay. That one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody...
Just 1 second.
You may. Do any need to have a restroom break anyway? Let's have a short recess while they get that queued up. It's about time for a restroom break.
Pass it up.
Yeah, thanks. All right, we'll take however long it takes the jury to get back, 10-ish minutes.
Impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right,
That's 4 times.
thank you for clarifying that.
Your Honor, may I briefly respond?
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and
Which
to the
I
extent that
just
it
got a
wasn't.
copy of.
Yes.
Okay.
And also, I just want to say that
No Georgia law that.
right, Georgia law does not define. It does not define case in chief. It does not break.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Miss Love intentionally, I assume, she has a memory of this because she was here. I hand her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package, I may not have put this in perfect order because one of them were not stapled, but you should have the United States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is Lexis 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given the honorable court and the parties. And if you can turn to that page, if you don't mind.
I'm there.
On the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the 4th Circuit held, encompassed both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The 4th Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young. But Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the first the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be GREEN, no E at the end, and it's 368 Georgia Appeal 74, 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is Pipkin, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded it because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. Mm-hmm. And the footnote they wrote, and I'm quoting, we also agree with appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tally them, but TALON note was in fact a discovery violation, given that Talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and then it gives the two code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this Honorable Court and the parties a copy of both code sections, OCGA section 17-16-4. And if you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this Honorable Court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 17-16-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, papers, documents, photographs, tangible objects, audio and video, tapes, films, and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to Honorable Court and the parties. Mm-hmm. And that has, if you give me 1 second, that has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control. About a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far.
You don't want all this. I don't know. I think he the one that got shot in the head. I don't. Like, everybody been said he hadn't died first. Like, that's what they were saying at first.
And Judge, just so that the court has further context, Shamel Drinks is DFW, and DFW, I said that wrong. Hold on.
Regardless, it says he's hanging out with the same people he grew up with, and then investigator Dennis improperly.
Oh, yeah, no. She
Yeah.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying about that.
And, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that.
Okay, so 13 is the end of the Rich Homie Kwan
Right.
barbershop.
Yes.
And then they start talking about Tay shot Kel.
And
I don't represent Tay. Tay's not associated. So, but it's just confused. I just think it would be confusing.
Why is it?
Tay is associated. That's what we were just talking about. Tay being Trevante.
Right. Who is dead and not on trial here, right?
That's true, unfortunately.
Okay. So is it relevant? I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
8 being page 36, lines 1 through 30.
I'm sorry, I hadn't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And, Your Honor,
And
I think I may have made an error on that. I don't. Yeah, I think it goes to.
I don't mind all of that.
Okay, so now we are to 101, line 20, out by agreement.
Judge,
Yes.
if I may,
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, I'm going to invoke my Fifth Amendment privilege. The state came to me and said, okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you, I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland.
Your Honor.
About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
when did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home, and then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and that my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But, whether or not.
And Adriane, it's my understanding that Mr. Melnick called Mr. Copeland last night. Yes, so it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay?
Of course.
And that sometimes has to be explained to witnesses and clients. Okay? All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So, we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to, ask that the court, convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, you know, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
All right. Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there is nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you have put us in a situation where now, you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my announcement for me.
Then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll have somebody go on Monday.
And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm going to talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me. And consider the motion to suppress statements of defendant DeMontre Kendrick, and also to take a look at the state's response in respect to those particular assertions in terms of the for Jackson Daniel hearing, which the court has to make those determinations of voluntariness thereof.
I'm sorry.
What was the last thing you heard, Christina?
Application in terms of the Jackson Daniel hearing, which
the court has to take into account to determine the voluntariness of the statement. In such, I have considered as well, and will be admitted for purposes of the motion to suppress Jackson Daniel hearing states 1 and 2. Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more. And at the second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
You have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Uhelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it of page during the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, with the appellate, case law that I've looked at, in Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
The video does not encompass when the defendant actually reinitiated contact.
But the problem is he invokes, and then We don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
They should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as the burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite at the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then saying, oh, well, let me just clarify with you a little bit. Now, that's not how this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now. And that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with things.
That's my ruling. And prepare an order suitable on my directives, Mr.
Yes, Your Honor. Thank you.
Mr.
Your Honor, we have not presented any evidence regarding what happened in the Sally Port. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time in terms of, because he's invoked, anything after that would be improper. It really would be, because it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or, kind of make vacillate. But he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. So
that's your ruling. Thank you. I have nothing to add, Your Honor.
All right.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, and that in this particular circumstance, this court's of the opinion that once you, I mean, it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
if you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35, Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point,
Your Honor, I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop.
Hey,
I was speaking.
Ms. Love,
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it. Yeah. I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring, and you know it.
No, Your Honor, I was saying that we were ready to present evidence, and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof, and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened when the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paul Doe, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire. It's, quite disturbing. But I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom. And the court's whole purpose for having these hearings is to determine the truth and to decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
May I please speak? Please, may I please speak?
Okay.
And Your Honor, I was asking that the court.
Are you finished now?
I was not, Your Honor. I was
Your Honor,
hold up. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe, if not today. I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer, he invoked his right to not speak anymore, and I don't care.
What are your thoughts? I know we are not the only ones who are seeing this. Leave us a comment. Don't forget to hit the like button and subscribe to the channel for more content like this.